I forgot. So I'm going to record this. I'm going to start recording. So I forgot. Anyway, never mind. So failure to report. Failure to report, that's the first thing they look at. So your reporting duties are so important. So if, for example, if someone doesn't start the role for which they're being sponsored, so you need to report any reason for non-attendance, even if it's a missed flight, even if it's illness, even if it's bereavement, you need to report that if they don't come. If they're absent from work for more than 10 days without permission, you must report within 10 working days of the 10th day of absence. So if they just don't come to work for whatever reason, then you've got to report. If they are debarred by DBS, if they do anything, then they're unable to work with vulnerable people, you've got to report that to the Home Office. If you stop sponsoring them for whatever reason, if they're absent from work without pay for four weeks, and it's not covered within any of the exceptions. So there's quite a few exceptions: pregnancy, maternity leave, sickness absence, bereavement. So if there's nothing particularly why they're absent from work, you've got a duty to report them. And one of the things that some people are doing is they're assigning COSs to their relatives, and then the relatives don't like it, so they go back to Zimbabwe, and they think they've got this multiple entry visa where they can come here, go back, come here, go back. So those absences, and when they're not reported, they're a breach, and the responsibility lies with you, the sponsor, for not reporting. If there is any significant changes in the sponsored workers' employment. So this is one area where we've seen a lot of people falling foul. So I've heard a lot of people say this, and I think even us, you see someone who's really good, they're a carer, and you think this one is very intelligent, so you then promote them to work in the office as administrative staff, as a care coordinator, as there's some people who are just intelligent, and you think, yeah, this one, operations, this one, this, and you've promoted them. You've changed their job title, you've changed their job description, and you haven't changed their salary, or sometimes you have, but you haven't notified the Home Office. So if the Home Office comes and they come for an inspection, what they look at is they look at their surroundings. They look at who's in the office. So when they never think those people are your friends. They're never your friends. The Home Office is not your friend. They come in there and they're smiling at you, and some of the people from, they'll smile at you and they'll be plotting murder. So they'll look at who is in your office, who's working, what are they doing? They'll ask them, what's your name? They'll check the COS. They're busy answering phones. They're busy being administrative staff. They're doing the rota. They're even helping the Home Office, giving them the files. They're there helping. They'll come back and say, that person has got a SOC code 6145. They're supposed to be a home carer. But what were they doing in the office for all of the days that we were there? So they'll say you haven't reported a change. You haven't changed their employment. So that is a breach, because you didn't have, what they then say is it's fraud as well, because you didn't have a genuine vacancy for that person. You brought them for the wrong, with a job that's lower than the level that they're actually doing. And so you are in breach. So they will also ask the person, what do you do on a day-to-day basis? And you know how the Home Office asks questions. They'll say, oh, tell us about your job. right, and what do you do? And they're very nice. And some people will be thinking they are being, they'll even be eager to say, oh, and I help the bosses with this and I do this. That's what they then use against you, because they will then say, no, your job is a carer. You're supposed to be going door to door doing domiciliary care, or you're supposed to be doing supported living. Whatever you have written on your COS, that's what they expect that person to be doing. So when they find that you haven't reported a change in their employment, that's a breach of your reporting conditions. So that is one of the things that they take so seriously. And we've seen that time and time again, there's a pattern, because some of the people coming from abroad, they've got degrees, they've got a lot of skills. So they're being used for other roles within the company. And that's not right. And the Home Office will pick up on that. So that change, that failure to report a change in their employment, it's a big one, and it keeps coming. And I think we all do it. We do it because we see potential, and what we want to do is to give them something that benefits them, that challenges them, but that also benefits organization. So what you're supposed to do is to change that person's code and their COS. It's a change of employment, give them a new contract, change it completely and promote them. So that's fine, but it's where you keep them in that position and you don't change, where it becomes a problem. If you reduce someone's salary, so this is something that from the level stated on the COS, and you haven't reported it, that's a breach, and you owe them money because it's a breach of contract. So if you have taken people using the COS, the SOC code 6146, and then they're senior carers, and then they're not doing senior carer roles, but they're doing home carer roles 6145. That's very common, and that's a big breach as well, because a lot of people did that, because when senior carers were first introduced, those are the people who came initially. But what people really wanted was the home carers who are 6145. So when the Home Office does interviews and they hear that someone is not actually doing any senior roles, but they're doing junior roles, that again is another breach, which they take so seriously. So people have to do the job that is on their COS, that is on their contract, that is on their job description. That is the work that they're supposed to do. And when the Home Office comes to interview them, that is what they're supposed to tell them that they're doing. So the way they find out is through observation, through interviews, through rotas. So if someone is in the office and they're not going into the field, when they do the inspection, remember I said that it's like a forensic investigation, they will ask for rotas. And they want to see that person's name on the rota in the field as a home carer using their SOC code 6145. If they're in the office, they're not doing their role. If they're not on the rota, where were they? Why were they not there? Were they absent? Why did you not report them? Where are they? So the Home Office will ask all of those questions. So they gather their intelligence through what you tell them, through what they see on your rota, on your systems, through your staff will tell them during an interview. And people get very scared in these interviews, and they just start, they just tell the truth anyway. They just start talking and saying what they do. So that is a failure to report. That's a big one, but mostly in terms of the jobs, where the location changes, where the worker is working at different clients' sites. So that another one is another big issue, which we've seen where there's been a lot of breaches, where you are supplying staff. So where you have recruited staff for your organization, but they're not working for your organization. They're working maybe because you don't have hours, you are loaning them to somebody else, or you are sending them out so that they have pay, because this stuff is pressure. If you've got stuff that you need to pay, you then start to use them for supply. So the Home Office, if they pick that up, because they're not on your rota, because there's they tell them that I went to work at the Gleb's nursing home, and then I also went here, this is what I've been doing, and they tell them all of these things. Then the Home Office will say, right, you have been what? You've been supplying. So that's a change in their job description. It's a change in what you've told, because you've told the Home Office that these are for you. So that's a big one, where many people have been picked up on that. It leads straight to suspension and revocation, because you can't even explain it, because you're not supposed to use them for agency. They're supposed to be working for you. So where you are supplying to other organizations, it's a problem. And I think one of the things that we say, and people, we think that they'll never catch us. How will they find? How will they know? How will they know? They will find out, because the person will tell them. They will check your rotas and your systems. They will check your bank statement. You've signed that they are allowed to look at your bank statements. So they'll look at your invoices. They will look at your invoices. They will look at your staff's bank statements to see that the money you are saying you're paying them, you are paying them. So where we hear people say, just do 20 hours. If you don't have hours, people must just do 20 hours. The person who's going to get into trouble when they get an inspection is the employer, isn't it? Because they're not providing the hours, they're not doing what they're supposed to be doing. So if their license gets suspended, revoked, then it has a ripple effect onto the staff. So that is another big issue. And that's all with, failure to report changes in their working conditions. There's quite a lot of other things, but so there's other changes that you have to report if you go insolvent, if you are involved in a merger or takeover, bigger things. If you change your company name, if you change your branches, if you sell your business, if you are convicted of an offense, you would have to notify the Home Office. So there's changes that you must report, which the Home Office look at. So generally, that's what they start to look at when they come in. They look at the COS, they look at the jobs that the people were doing, they look at the rotas. They will just be looking nicely, and they'll be coming up with a lot of things that they come up with. Tamari, you had asked, is the COS for carers ending soon? The Home Office said that they would put it in place for a year until February, and then review it. So the review is ongoing, but the information that we are seeing in terms of the shortages in healthcare, the crisis everywhere, I don't think that they will end it, because they still need the carers. The carers are needed. Where would they come from? I don't see them ending it, but maybe tightening, like what they're doing now with these inspections. They're tightening things up, so they might do more inspections, revoke, they don't care. They revoke licenses so fast. They really stamp in and come in. So I don't see them totally removing carers, but I do see them tightening things up in terms of regulation and compliance. And that's why it's important for everyone to be compliant and to ensure that we do things the right way. Uh, 6145, you were saying, is it going to be removed? I don't think so. But like I said, yeah, so I think I've answered. So you can change it. If you give the candidate, if they've got a senior carer course, but the candidate promotion giving other positions in the office, how can we change? So you need to change them into the SOC code for the position that they have. So there's SOC codes for care coordinators, for administrative staff. There's SOC code for everything. The thing is, 6146 and 6145, because it's a shortage occupation, it was just simply easier. So whereas others, you do have to show that you've tried to recruit and you haven't been able to find people in the UK. So you can still promote someone onto a higher level and just use the right code for them. So you can do that. If the company doesn't have work, which the carer has got a sponsor, the carer working on another company, that's a direct breach. So if the Home Office finds that out, the person who will suffer is the person who sponsored the person, because they have to have a genuine vacancy. So if you don't have vacancies, then don't sponsor people. Or if they've come and you don't have clients, but you've brought them in, then you need to make them redundant. You need to fire them if you don't have work for them. So the Home Office won't see that as an excuse to say, I felt sorry for them, so I kept them on my COS. That's a breach. So if you don't have work and you've brought people in, then you need to get rid of them, which is quite tough. But that's the reality, because the job, they're no longer needed for the job. So people are made redundant all the time. So if you lose contracts, if anything happens, then you would need to make arrangements to let go, so that they can go somewhere else where they're able to get the hours and they're able to work, not loan them to somebody and keep them on your COS, because that, if you're caught, then that's a breach. And the other way that the Home Office can catch you, if they is through the Inland Revenue. So because remember I told you that they look through your bank accounts, right? So some people, they think they're clever, so they do tricks where where you have money coming in and coming out, which is paying someone who's not really working, right? So, and then you're paying tax for that person and national insurance. But when they check through bank accounts, sometimes they can see a trend and they can see a pattern and they pick it up. Whoever has gone through asylum interviews, you know how the Home Office is. So now this team is even worse, because these ones, they're looking at things forensically. They're looking at the figures, they're looking at it with a fine-tooth comb. So those are the things that they come up with. For wider experience, yes, or if you have an agreement to say that they're getting more experience in certain things, if they're working outside of their 20 hours, the important thing is that you need to have given them enough hours. So in your organization, you need to have given them enough hours. And then anything they get extra from other organizations, that's fine. But in your organization, you need to have made sure that every month they have got enough hours of the hours that you have said on your contract that you're giving them. So that is very important. It's very, very important. And where you have an arrangement to say that they're getting experience in another sector, or it's you're, what can I say, exposing them to a different client group or something that you are doing, then you have that arrangement. That's fine, but not where they're completely somewhere else. So that again is important. So where you're topping up their hours, thanks Shami for that question. If you don't have enough hours, can you still top up their wages to match the contracted hours? You can. You can top up their hours. But one thing that I've seen is the rotas. So because they check on the rotas, that your rotas, they check on your rotas how many hours they've worked, then they align that to your payslip, and then they align that to the bank statement. So those are the things which sometimes you can top up, but it can still be you don't have contracted out, you don't have sufficient hours. So it depends how many. So sometimes in some inspections where we've seen that people have not what can I say, that they haven't done the hours because they're sick or childcare, the Home Office have asked explanations. They've asked for you to justify why that person doesn't have those hours for that month. So they're quite strict. The additional, what limitation type of work for the additional 20 hours can they do? So it's in the same code, in the same SOC code. so they can do the work in the same category that they have. If it's in a different category, they need to get another COS. So you can actually have 2 COSs if you've got 2 different jobs. So Portia, thanks for that question, because that's something that a lot of people have got problems with. This is not very pleasant, guys, but the consequences of losing a license, it's worse than getting things in order. Because if it's revoked, you lose all the stuff, and then it's a bit of a nightmare. So what if they come as drivers? So if you've advertised and said that you need a person who's a driver for the job, and one of the requirements on your job description, in your contract, they said that you're supposed to drive and you can't drive, and it's a requirement. It's driving essential and they can't drive. That's a competence issue, isn't it? So you would have to deal with it in terms of your competence. You'd have to deal with it to say, to take them through your procedure in your company, whatever your procedure is for performance appraisals and things like that. So if you're unable, if it's causing you a problem because they can't drive, you may have to let them go. And you would have to have that conversation, document everything and put it in place to say that you can't operate like that, because it's now your business needed a driver and you don't have a driver. So it's better for you to actually have that difficult conversation to say, this is a requirement. And what's important, I suppose, is that from the outset, you've made that very clear. And so driving is essential. It's an essential part of the job. And so if a person is not able to drive, then that becomes a problem for you. You need to then take them through your own HR procedures and do something about it, because that's it, isn't it? Because you might think you're being nice by keeping them, but then you're not giving them hours. That same person is the one who's going to go and report you that they haven't been giving me hours. So you might have to be quite tough and do that if they're not competent, if they don't meet the requirements of the job role. So 2 COSs for different roles. Is that 2 for one person? Yes. So yeah, so a person can have 2 COSs. If they are doing more than 20 hours, if they're doing a job in a different role, they can actually have, at the same time, they can have two ones, yeah. Thank you for the questions. I hope it's making sense to everybody. For the people who are not asking me questions, I hope I am making sense. What's our time? Okay. Another issue which comes up a lot is assigning a COS where there's no genuine vacancy or role which meets the worker or temporary worker criteria. If you assign a COS and it's not considered a genuine vacancy, the Home Office has a right to suspend your license pending further investigation. So that also comes with where you're supplying a lot. Like there's some people who no one works for them. 100% of their workforce is being used as supply. So that is a big issue where 1 or 2 and you have an explanation why. You would have to have an explanation, but where people are permanently agency, it's a big problem, and that can lead to a suspension and a revocation. Failure to disclose if you assign a COS to a family member or of anyone within the sponsor organization, if you're classed as a small or medium-sized business. This is another big issue where you assign to a relative, you don't tell the Home Office. And that failure to disclose is seen as a breach, and it's quite a common breach. how does the Home Office find out that you're relatives? So some people will tell them in the interview, it will slip of the tongue. Sometimes you've got the same mother, same father, or same one mother. And you know, when we apply for visas, you always put your parents' details. So it clicks when they can check with previous visa applications. If they want to find they can find a lot of information. So it's best to have somebody else assign the COS and just declare it. So it's not that you're not allowed, but it's the failure to disclose, which is the breach. So if you have a level 1 user who assigns to your relative, you tell the Home Office in a sponsor note, then you're covered. So it's the failure to disclose, the deception, that becomes an issue. So the Home Office is quite strict about that, on how they find out. When there's no role to fill and you've assigned COSs because you're making money from the point of sale. So where somebody is selling COSs, they don't have jobs, but they're amassing a lot of people here. That's not a genuine vacancy. So this is one where we see a lot of issues about a genuine vacancy. So I think I've covered this before. I've covered it in terms of where somebody's doing, where a genuine vacancy is one which requires the job holder to perform the specific duties and responsibilities for the job and meets all the requirements of the relevant route and does not include dissimilar or predominantly lower skilled duties. So this was quite a problem when with the senior carers and the junior carers. So if you're a provider who has allocated many senior carers, and you don't need that many senior carers in your organization, then you need to change. You can do it before you get an inspection. So if you see that you've done something that's not right, you can do that. If you have 100 people that you have assigned COSs to, and you're a small business with very few contracts, then it's not a genuine vacancy. The Home Office will look if the number of people that you have is appropriate to the business in light of your business model, plan, and scale. So they look at everything in a really holistic manner. And they want to see contracts. They want to see that you've got the jobs that you're saying that you have. So the type of things where they're saying that they're not genuine, a role that doesn't actually exist. So when you create a role and it doesn't exist, one which has been exaggerated or an incorrect job description. So that's where now a lot of people who are assigned senior carers, that's where people have fallen foul, because they were saying you exaggerated the role to a senior carer. So now it's not such a problem for like new people coming in, because you can just assign them at the lower level. But for people who started, because it was the only category, it actually has caused a lot of problems. Because they're saying it's a sham, and you're doing it just to bring people in. So where you've got a job or a role that was created to enable an overseas national to come or stay in the UK, then it's not a genuine vacancy. Or where you are excluding settled workers from being recruited. So it's always important to try and keep your people on your books. Just have a balance. Don't only have migrant workers. Do try and keep some of your settled workers, because they want to see that you're still recruiting in the UK and you still have people. So what some organizations do is if you've got, like, you may use your migrant workers for your core business, and your settled workers, you use them in supply. So if you've got a combination of supply and a core business, you can do it that way, so that you still maintain your UK staff so that you don't lose them, because they do want to see a balance of staff that you have. So if you get rid of everybody who is a settled worker, they may see that you're only having this job to bring in migrants and to make money from COS. So I'm wrapping up now. The other things they look at is complying with the wider UK law, so employment law. So things like bullying staff, harassing staff, racial discrimination, and racial discrimination, even if you're both Zimbabweans and you discriminate against another person by telling them that you Zimbabweans are a problem, that's racial discrimination, because you're discriminating against them because they're a member of a particular group. So I think a lot of us don't know that there is actually a case that has gone, that's recorded, an employment law case. I've used that argument for one of my clients where they were discriminated on for being a Zimbabwean, and we argued that that's discrimination on the grounds of nationality. So it is discrimination. Sexual harassment, that is something that is so prevalent at the moment. It's so disturbing, the amount of sexual harassment that is going on, honestly. It's not right. Rape, sex for hours, sex for COS, for switching. So that type of sexual harassment it's not complying with criminal law, employment law. So it triggers an inspection when a person reports rape. Human trafficking for the purposes of prostitution. That's something else that we're coming across, which is alarming. So when a person breaches the wider law, so employment law, through discrimination, unlawful dismissal, dismissing someone for whistleblowing, harassing and bullying. I've had some audios, and just to sponsors, guys, because you know what, a lot of people who are being recruited are young, tech savvy people. They record everything, and some of the recordings that I have received, it's so uncomfortable to listen to, where people are being humiliated, where people are being shouted at, where people are being sworn at, and that's by your employer. So if they are to challenge the dismissal, constructive dismissal, bullying, they can take that to tribunal. It then triggers off to the Home Office, and it's a cycle. So the police can then trigger, if someone reports a sexual offense, it then goes to the Home Office, and it leads to obviously to a revocation. And yeah, it's quite scary. And I say scary because it's just too often the number of reports that are being made, and people are quite scared. So breaches of the law in terms of all the different types, criminal law, employment law, all of that, it can lead to the Home Office suspending or revoking a license. Wage deduction, where you are deducting wages for anything, if you whatever you are deducting the wages for, and some people deduct wages where people haven't met the hours. They deduct wages where people haven't where they've damaged like a car, you're not allowed to deduct the wages. You have to pay the person their full salary, and then they have to pay you if they owe you money for something. But it has to be very clear. So you can't dock their wages and then say it's minus something, because that's then, they then calculate the remainder. So what they do is they calculate the remainder of how much you owe them. So where you've deducted unlawful deductions, say someone is left with £200, they divide that by the number of hours, and they say you were paying that person £2 an hour. So it's modern day slavery. So then it comes with a criminal sanction. So where there's unlawful deduction of wages, the consequences would not just be with the Home Office, but it also can be criminal. And when it's done systematically and often, it then becomes a very serious issue. Where you're not paying people's pension, where you're not paying their tax to inland revenue, where you are not keeping up with your PAYE, where you're taking money from them, but you're not repaying HMRC, that becomes an issue. And the Home Office work with their colleagues at the inland revenue. So some of the inspections are triggered by HMRC, because when you apply for the COS, remember you put your tax reference. The reason you put your tax reference is so that it now links the Home Office with the tax office. So even before you know that they're coming, they would have been triggered by themselves that this person has sponsored 100 people, but the amount of tax that they're paying, it's not, the PAYE does not equate to the number of people that they've brought. What's going on there? So that triggers sometimes inspections. CQC can, if you fail a CQC inspection, that can trigger your license. It's all linked. Planning laws, all sorts, whatever law. So they expect you to comply with the wider law. They do. Yeah, let me go on there. So behavior that's not conducive to public good, that's just a wide, broad thing, fostering hatred, inter-community division. So sponsors, be careful of what you say on social media. Don't rant. Don't rant. Don't rant about Zimbabweans, because the Home Office, they say all sponsors have a responsibility to behave in a manner that is consistent with our fundamental values, and it's not detrimental to wider public good. That's what they say. So they say such actions and behavior, such as fostering hatred and inter-community division. So fights between newbies and oldies, labeling them all as people who've come to steal our husbands. When there's people rant on social media and say what they think, or even say it, So sometimes that can be seen as something that's not conducive to public good, because it's fostering inter-community division, terrorism issues, discriminating against other groups, discriminating against individuals on the basis of their sex, age, disability, gender, reassignment, sexual orientation, etc. So that in the workplace, if you have a discrimination case that goes to the employment tribunal, then it can come back onto your license. When we ran RBM solicitors, we once had somebody who threatened to take us to tribunal. It didn't go all the way because they said that we were discriminating against them on the basis of their race. And all of our staff were Asian, but I don't know what I said. I think I said something about a comment that a client made, which talked about curry or something that was very like a stereotype comment. And one of our staff was very upset about that, and it was an issue of discrimination. So sometimes it didn't go far, it just stopped at ACAS. We didn't go to the employment tribunal, but staff can take you to the tribunal for all sorts. I think everyone knows, all employers know that staff can take you to the tribunal for so many things. And so we must be very careful in terms of how we speak to them, what we say. Ageism, discrimination on the basis of someone's age because they're too old, or because they're too young, or because they're a woman, discrimination on people because they are single moms, discrimination on people because they're gay, discrimination because of lack of belief. I remember one case that was taken by a colleague of mine, where somebody was being discriminated against because they were Shona, the agency belonged to a Ndebele person, and they said everybody had to learn Ndebele, and they were quite ruthless in that, in what they did and what they said to them. They said it to them in text messages, voice messages, saying things to staff, and they made a claim, and you have to pay out. So it's better, to avoid having to pay out to people, because the one thing I've also seen about the young people who are coming, I think everyone talks about it, is that they're quite, they know their rights, they really know their rights, and they know, because their rights are there, they're on the internet, they can research, they can look at them, they don't even need to be told by other people, they know, and they can assert their rights. And some of them are young, they're these Gen Z, so they're quite tech savvy, they quite know what their rights are. So there's cases going to the tribunal for all forms of bullying, harassment, discrimination. And so when that goes, that can then end up now making you lose your license. So it's not just that one issue, it's a ripple effect. And what happens if you lose your license? The consequences are not good. The consequences are not good because, like I said, the Home Office can downgrade you, which is okay, but they can also suspend your license. They can also revoke your license. If they revoke your license, they also notify the CQC, they notify the local authorities where you're providing services, because it's also, if you're going to lose like a huge chunk of your staff, it's going to cause a crisis in there, because if your license is revoked, then you have to stop employing those people from that day. So the consequences are quite serious in that you have to, your services will be affected, and it can affect your livelihood. So it's important to take these things seriously. Please take compliance very, very seriously. I know this has been a whistle-stop thing, but it was just important just to address some of these issues, so that we hold our sponsorship licenses like a baby with fear and trembling. We've got to really hold them carefully. Take compliance very seriously. If it means that you need to, if you have the capacity to read through the guidance yourselves, read through the appendices, make sure you know what you're supposed to be doing, because ignorance of the law is no excuse. It's not an excuse to say, I didn't know. It's not good enough. You should have known. And you actually said that you would read those guidance when you applied for your sponsor license. So they're not going to take I didn't know as an excuse. You have to have, you can also have mock audits. You can also seek advice from professionals like me, because I take time to read the guidance. So I go for training, I go for so many training on compliance, on everything. We end up having to go, but also experience from what's happened to other people, because some of the things you wouldn't know. And so when you get advice, you also have the benefit of that, because you know what other people are doing. So I think that's it. I think it was, I'm just over by a little bit, but I'll just run through the questions. If anyone's got any comments or questions, please, you can ask in the chat, or you can even unmute and just ask any question or comment that you have, or if anyone's had an experience with an inspection or anything else that you want to quickly share, please feel free. You have to update the Home Office each time you obtain new contracts or new homes. No, you don't. New location. So if your business, like if you open a new branch somewhere else, you have to notify the Home Office. If you're a nursing home, for example, if you're an Ofsted registered children's home and your license is for that home that's regulated by Ofsted, and you open another home, you have to notify the Home Office. If you're a nursing home and you open more branches, you have to notify the Home Office. But if you get a new contract somewhere else, you don't have to notify. If, say, you're unregulated, or if you're providing domiciliary care services because you operate them, if it's a different branch in a different town, then you would have to notify the Home Office. When you registered and you said you provide domiciliary care services in Coventry, and then now you are providing them in Southampton as well, you would need to notify the Home Office, because if they see your people working there, they might think they're not working for you. So yes, you'd report that change. So it just depends. The switching, I don't know why the COS is for the switching of the ones for in country are taking so long. Or for people who are here in the UK, and the Home Office asks the details every time, yeah, because they want to know why you want them. They have a right to ask you whatever they want. They can ask, and they do. They ask, they sometimes even ask for the names of the people that you're sponsoring. They ask, so yeah. No, if somebody damages your car in the line of duty and you ask them to pay for it, that you can tell them that it's going to cost £1,000 to fix. You owe me £1,000. I've paid it, and so you have to pay it back over time. And so if it's 6 months, if it's whatever, then you give them their salary and then they pay you. You can't dock their pay. That's what the Home Office doesn't want you to do, is to dock their pay, because that's open to abuse. Because some people are gangmasters who charge you like the debt never finishes. So they'll charge you a lot of money for coming here, and then they keep taking it every month. So you're always in servitude. So that's what they want to avoid. So you can get your money back, but they need to pay you back. I hope that makes sense. So they have to transfer it to you or give it to you, not you take it without them having had their full salary. Rent deductions, no. So same with rent deductions and company loans. I've had one inspection where the Home Office said, no, it's unlawful deduction. I was going to just read what they said, but yeah, they didn't want that. So even though the deduction was justified, they said you shouldn't make deductions. They should pay you back. So that's one thing that was surprising for people. So deductions, e.g. flights and visas, is if you say to them you're advancing them a loan, then they have to pay you back, but you can't take it from them. I hope so. You are allowed to get your money back, but you cannot take the money back. So if you say, I'm going to give you a loan where you I pay for your visa, and I pay for your air ticket, and I pay for your English, and I pay. So the Home Office have got a guidance, which I will share with everybody. So they issued a guidance towards the end of last year, where they talked about the deductions and how you can do them in a safe way, in a way that you're not breaching the law. So I just don't have everyone's details, unfortunately, but there's a link, so I'll share it to the people that I've got their details. Read that guidance as well, because that shows what they expect from you as well. And the other thing which they're clamping down on is the charges. When people are making the charges for visas, you're not supposed to charge for the COS, for the immigration skills charge, but you can charge for certain things like airport runs and things like this. I've seen the Home Office scrutinizing, like literally going through with a fine-tooth comb the charges and asking you to justify and break down what you are charging them for. So if you charge £7,000, they're asking, what is this money for? Tell us everything. What did you charge them for? So and people are not good, you guys. So you might think that you're charging them and you've got a secret they're not going to tell. When the Home Office is interviewing them, yes, I did. I paid. So they then ask them, so tell us, what is it that you charge them for? And then you will say, solicitors fees, this, but they want to know that the charges are fair and reasonable. So you can't charge 200-300 for an airport run, for uniform. So they were now going through with a fine-tooth comb to find out what it is that people were charging for. So yeah. So there, it's a dangerous game. People are not loyal, and especially these Gen Zs, these AMA 2000, they are not loyal. Honestly, it's you have a nice agreement, but so we have to be very, very careful and extremely careful, because there's a lot that's going down. So yeah, good. No, that's great. Thank you. So yeah, so I think that's that's it. I think so. What we do is I apply for sponsor licenses, do compliance checks virtually. So if you want us to just go through your compliance checks with you virtually, we can do that. We can actually just usually it's about for 3 hours or so. We set aside time. Myself, some of you know Fahana. And we go through the COSs, your processes, what have you been recording? One of the things that they want to know that you are recording is addresses. So I know somebody was pulled up for not having the change of address because they asked the people, what's your name? So-and-so, where do you live? And they wrote down the address. But when they now looked in the employer's system, it was a different address. So they said, you're not keeping records. You don't know where this person lives. You are supposed to be the one who's looking. You're supposed to be monitoring them for us. So if you don't know where they live, poor record keeping, another little black mark. So we can go through your compliance checks, make sure that you've got everything, even though you've applied for a visa for someone, you shouldn't assume that the Home Office will know. So you don't keep a record of their visa. So you need to keep a record of their BRP on file, their passport, like what you do with immigration checks for people you've employed. So some people will be thinking, but we applied, we know they've got a visa, but they still want that. So that's another breach again, sometimes where you don't have your records, and they want to know that you've got different systems of knowing when their visa is going to expire. So if you use an HR system like Breathe or something, it needs to tell you. If you use Excel spreadsheets, you need to show how are you going to be reminded. Have you got an Outlook calendar as well? Have you got paper-based? Have you got computer-based? So they want to know that you've got all the things to trigger when their visa expires, so that you keep on track of that. So especially for those with like 1-year visas, 3-year visas, you need to also have a system where you're keeping a track and a record of that. So when we do the compliance checks virtually, we'll be going through everything with you to check, to make sure that you've got everything in order. And then we also do on-site mock audits. We interview the staff and we check the files. So we can come to you and we can do that. And interviewing staff is very important because they need to know how to conduct themselves in an interview. Some people get too excited. I know Faris, they just get too excited. So people need to know how to conduct themselves well and answer the questions that they've been asked. And so interviewing staff is another thing that's really important, checking through the files and doing an on-site mock audit. And also some people, when they've got an inspection, we do a preparation for the inspection and just help them. I think it's better to do it before, just do it before, not wait for an inspection, because you might not have enough time. And if you need to change things, promote people, do whatever you need to do, you then are able to do it in time without the pressure, and just to put everything in place. And sometimes we then respond to queries after a suspension. So we're able to then to do that as well. So that's the business immigration work that we do. And those are my contact details. Right. Thank you. Great.
Thank you.
If you could.
Thank you, Ruby.
All right. Oh, that's great. Thank you. Please pop your emails in the chat if you want the slides, so that I can send them to you, and then I'll save the chat afterwards. Thanks, guys.
Thank you so
Thank you,
much.
Stephanie. Thank you.
Thank you very much. Good night.
All right, that's great. Good night, everyone. Good night.
Yeah, thank you. Bye.
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 Thank you.
Thank you so much.